was fantastic, and we're looking very forward to hearing Mark talk tonight. Mark's been part of the firm for about 5 years and has been an attorney for about 10 years, and he specializes in property litigation. So we're very keen to hear what he says tonight on the topic.
Good evening, everyone. Thank you very much for joining us. Thank you to Ellen for the lovely introduction, and thank you to all our staff and to Nikita for putting tonight together and for all the hard work. So the topic for tonight's conversation is something which I think is very important to all of us here, which is basically, what are the rules regarding this whole commission story, right? It's something very dear to all our hearts. It's what we put in our many, many hours, and it's what we focus on. And what I want to try and do is just try to do a better discussion with regards to what are the legal implications, what can happen, and what are the best means of securing and ensuring that that commission's paid. So, obviously, when we're talking estate agents commission, as with many things, the best way to look after ourselves is before the party starts, right? When the seller first comes to you, says, okay, sir, I'd like you to sell my property and whatnot. Ideally, this is the best time to put everything in place, right? To make sure that everything is correct, that proper agreements are signed, that mandates are signed, and it's these little things with paperwork that sometimes can make what can be a complicated situation a very easy situation. One of the things to watch in our experience is mandates, and making sure that the timing on the mandates is kept, because often what happens is that we get a property, and sometimes the property doesn't sell as quickly as the seller believes it should sell, and what happens is that the mandate runs out, right? And that the period that was agreed to, be it a year, 3 months, whatever it is, has elapsed, and now we're in that grey area. So the first trick, shall we say, my first recommendation is try to keep things easy and simple before it ever gets complicated. Make sure that the mandates and the agreements are kept to date. If you see that it's running out, sign a new one. Now, I know what the big problem is. The problem is especially with people you have a good relationship with, or sellers who've been around for a while. Sometimes the feeling is, oh, but he's a good guy. You know, I go to his house, I've been there, I've done 5 show days for him. I know the kids, I know the wife. Don't worry, when the time comes and the sale goes through, he'll look after me and he'll honor his agreements. And the big problem that we sometimes have is, sometimes the bigger the house, the bigger the purchase price, the bigger the commission, when it comes time to paying, that's, I think, sometimes when we find that the seller starts becoming a little bit problematic, because, I mean, why should he part with his hard-earned money? Or the money from the seller's property? I think this is a situation where we get into, and it happens. I've been involved in matters at basically every level, where it's your simple 200-300 rand house to your developments where it's 66,000 rand, where 66 million rand, sorry, where, to quote the agent who sat with me, the seller turned around to him and said, yeah, but I'm not paying for yesterday's lunch today. So, you know, these are all things that we really need to be careful of. So my first piece of advice, and I know it seems simple and silly, but make sure the paperwork is there beforehand. Be it a sole mandate, be it a joint mandate, be it whatever it is, make sure that that mandate is signed and is there and is in place. Because at the end of the day, if anything happens, that is the protection that you're going to rely on. That little piece of paper, you know, which is only one line and which is thrown around the office, that little piece of paper is the difference between an easy case and a complicated case. Because one of the things that we're going to discuss later is the aspects that a court of law is going to look at. And the truth is, if that mandate's in place, suddenly a lot of the issues that are in dispute suddenly get removed very quickly. So, simply put, the primary issues that a court that we look at is, unfortunately, as we know, is that sometimes we're not always in the situation where we're able to keep the mandate in place, where everything's signed. Sometimes what happens is a good house comes onto the market and there's more than one agent vying for the property, and there isn't, truthfully, as much as we'd like there to always be time to make sure all the paperwork's intact. Sometimes it's a luxury we don't always have. and we need to try and hope to recover that situation, be it later in the offer to purchase or in the actual sale agreement. Make sure that we protect it. We protect it in terms of the paperwork, which would be the second port of call if the mandate isn't strong enough in place. But the truth is, in our business, unfortunately, even that situation doesn't sometimes happen, and we find ourselves in a position where we have to find a way. How do we protect our rights? What is a court of law going to look at if I turn around and I do 5 show days every set? I'm doing show days on this house left and right, and I'm advertising it on the internet, and I'm advertising it on Prop 24, and we're taking buyers in and out, so we're making appointments. How do I know at the end of the day, even if my paperwork isn't in place, how do I know that I'll still be protected at the end of the day? And what is a court going to ask of me to succeed? So essentially, there are 4 main criteria, right? They look at the introduction of the agent to the agent to the purchaser. Looks at establishing that the purchaser was when the contract was signed, willing and able to purchase the property. Establishing that a valid contract of sale was concluded, right? Importantly, just to note on that you must be careful. You must note carefully sometimes in the mandates and whatnot that it says whether or not a valid sale was concluded. It's not always necessarily when transfer goes through. And it's a big myth in the market that sometimes a commission is only due and payable on transfer. It is possible to contract that the commission only becomes due and payable on transfer, but officially, in terms of common law and whatnot, a port of where a commission can be due is on conclusion of a valid agreement. So in other words, even if the sale should later fall through, or the purchaser doesn't get his bond, or the seller decides he doesn't want to say, truthfully, in most instances that you can find yourself in a position where that on that point, as long as there was a valid agreement concluded, and sometimes even if it's not a valid sale agreement, if the agent makes an introduction that later leads to an agreement, in other words, that maybe instead of the property being purchased, that a long-term lease is signed, that the business that owns the property is sold, or something like that, even in those instances, the agent can, and sometimes is, still entitled to their commission. The next point, which is the most important factor when talking about this, is, and it's something that I want to focus on a bit, is establishing that the introduction was the effective cause of the sale. And then the last point is the amount that was agreed in the commission. Okay. So like I said, one of the primary aspects that a court looks at is, was the agent the primary cause of the sale? That means was the agent's actions resultant in what brought about the sale? We're saying that we're talking about in an instance whereby there is an absence of an agreement. Because very often, if there's a mandate or something to protect us, it means that irrespective of whether or not the agent was the actual cause of the sale, the fact that a sale took place over that period of time, the agent can still be entitled to their commission. The question that arises, so in other words, that protects. The question arises that when there's no mandate or there's nothing in writing to protect the agent, what is the court going to look at as to whether or not there's an effective cause? Now, in most instances, we hope that the seller and the purchaser will be good, upstanding people, and they'll admit that, you know what, at the end of the day, you did your job. You took the purchaser to the property 5 times. You took him in the morning. You took him at night. You took him when it was raining, when it was snowing. All these different criteria. You showed it to him. You prepared the original offer. You took it to the seller. The seller rejected it because it was way too low. You then took the counter back, the purchaser rejected it because it was way too high. And you ran backwards and forwards and you juggled agreements, and what about the creepy crawly and the TV staying, and I want this and that to stay, and eventually you conclude the agreement. The point that the court is going to look at is, was the seller the effective cause? Or was the agent the effective cause? Did they go about? Now, obviously, this is where all those factors like that you prepared the offer to purchase, that you brought the buyer on numerous occasions, that you were the one who brought forward the offer, that the offer clearly states that you are the effective cause. All these kind of things are then made easier by this point. Okay. This is where it gets a little bit tricky. What happens Now, very often you find yourself in a position where when none of this happens and there's the dispute, generally you'll find that the purchaser is a lot more willing to turn around and say, look, the only reason I bought the property was because the agent took me and she showed me, and we went through every little crack in the building, and she showed me this. That very often is the purchaser willing to come to aid, which helps. Because the truth of the matter is, when there is a fundamental dispute and it gets to the court is going to turn around and say, who was the effective cause of this agreement? Right? And the fact is, if the purchaser is willing to do the right thing and say, because obviously in this circumstance, the person who wants to try and back out of the whole thing is the seller. Because at the end of the day, who's the one who's liable to pay the commission? The seller. The purchaser being willing to turn around and say openly that, look, agent did their job. Only reason I bought it was because of the purchaser. It's because of the agent. Purchaser being willing to make that argument counts a lot. However, what sometimes happens is we find ourselves in a situation where the purchaser turns around and says, look, I've got the house, I'm not interested, or I'm not getting involved. Or sometimes on some of the bigger properties, the purchaser turns around, and I can see that some of the older agents in the room will say, I remember that story happening to me, I remember this one, I remember that the purchaser turns around and says, look, quite simply, I don't want to derail the deal, and it's now between you and the seller. And then the court is going to look at extraneous circumstances, which we are going to come to, such as show days, track records, proof, even your little things like your WhatsApps and things like that. It can help. However, the problem that you find yourself in now is that you've got the dispute between you and the seller, and it becomes to a degree sometimes your word versus their word. So this is where the extraneous evidence, like the proof that the show day took place, the proof of the listing, the proof of all the offers to purchase and things like this, is where it can come to your aid, where you can say, look, this is everything that I did, and this is the guy who ended up buying the property from this guy, so I've done my job. I was the effective cause of the sale, so I'm entitled to it. It's a very difficult situation. The big problem, if we do find ourselves in these situations, is the big risk, is where the purchaser and the seller collude, and they both decide between themselves that they are turning around and they're going to say that, no, you didn't get nothing to do with it. That, yeah, you made the initial introduction, and but beyond that, the rest was done by you. Now that's not an unassailable position. Theoretically, it can be overcome. However, it's not an easy situation, because now you've got a situation where the two primary parties to the contract are both turning around and saying that you had nothing to do with the conclusion of that sale. In which case, like I said, it's not impossible, but it becomes difficult. This is where, like I said, the extra evidence that we can build up, the proof of the show days, the offers to purchase that you yourself prepared, that the purchaser signed, that the seller signed, that went between the parties prior to the conclusion of the agreement. This is where they start counting. And I'm not going to lie to you that in that situation where it is the agent taking on the purchaser and the seller, who are both willing to turn around and say that the agent had nothing to do and was not the effective cause, it's a difficult case. It's not an unwinnable case, but it's a case where we're going to have to sit down and we're going to have to look very carefully, and we might have to sweat it a little bit. But that's why I'm saying, as best as you can, let's try and not find ourselves in that situation. And the solution to not finding ourselves in that situation is the ridiculous paperwork that we have to go through beforehand. Because the truth is that silly paperwork beforehand, or what seems to be unnecessary admin or exhaustive, or it's delaying me from doing what I need to do and what I do best, which is putting people in houses and showing them and listing, that silly little paperwork, it counts volumes. I can't overemphasize it. However, on a positive note, so luckily, the courts have, on this one point, that there's quite a bit of case law on it, and the landmark case, which defines these situations, is a situation which basically goes against everything that I've said so far, right? It's the case is called F.P. Muller and Pam's Name Unincorporated. Okay? It was a case that was heard in 2000 in Cape Town. and it's basically been upheld. Now this was a situation where even if you work through the story where the judge starts relaying, it becomes very convoluted. So it seems that there was a junior agent whose aunt knew the seller, and because of that, this is how the whole story works. Because of the aunt, the seller gave the mandate or discussed the opportunity to sell the property with this, she's referred to in the case law as the novice agent. Gave the listing to the novice agent and told it to sell. Somewhere along the line, there wasn't a proper mandate in place, and so they work. And the lady who does all the work is a lady by the name who's referred to in the case as Mrs. Swart. Right? Now, it seems that the wording that gave rise to the mandate was, I want to read it because it's a horror story. This is the exact word as quoted by the judge. Yeah, please go ahead and see if you can find me a purchaser. Guys, exactly in the face of everything I've just said. And then what happened was, it seems Mrs. Swart listed the property and brought a number of buyers to the property, and it seems she did do quite a bit of work. And what ultimately happens is the property sold. It was about 2.5 million, and the sale goes through, and Mrs. Swart and this novice agent's company is now suing for their commission. And the seller turned round and said, I don't know what you're talking about. There was no agreement between us. Never heard of such a thing. Don't know what you're talking about. The court then goes into what is simply described as the most theoretical debate that I've ever really encountered in my life. It's talking about an implied contract. It asks itself, was there an implied contract or was there a tacit contract? Right? And it's very arguable in grey, like which one it actually is, and it oscillates between the two. And the court comes up with two tests, which it defines as there was no other reasonable interpretation test, or the most plausible probable conclusion test. So it basically then starts to analyze the actions of Mrs. Swart, and it says, based on the actions of Mrs. Swart, do these represent the actions of a person who wasn't properly or a person who wasn't authorized to try and sell this property? Could Mrs. Swart have been deemed to have been anything but an agent? And this is what it looks at. It looks at the conduct of Mrs. Swart, and it says that if you go through what Mrs. Swart did, that the only reasonable conclusion that it could determine was that she was authorized to do this, because she goes into stories about how she brought a student to see the property, and she brought this to see the property. And it goes through and it says ultimately that one of the people who Mrs. Swart brought to the property actually goes on to buy the property, and there was an agreement, and there was very importantly, there was no signed clear mandate. And the court, initially the magistrate rejected it, matter goes on appeal, and the High Court, I believe it is Judge Webster, turns around and gave the order in favour of Mrs. Swart and said Mrs. Swart was the effective cause. It applied the two tests, and it said that the only reasonable argument that it could come to was that Mrs. Swart was mandated and was properly authorised to sell the property, and she acted in accordance therewith. To which estate agents around the country let off a collective cheer of excitement, because now we know that we can still get our commission. Okay. And it even went further, which is why I like this case. That the question was asked, well, I said, okay, if there was no written mandate, and how do we know what the amount of commission should be payable at? Right? We know in our day-to-day lives when we sell properties, very often to try and incentivize and to sweeten the deal, we'll turn around to the seller and say, look, I know I'm entitled to X, but I'm willing to take, I'll take a knock on the con. let's just make sure that the sale goes through. So what happened in this case was they took a look and they said, what is the industry norm? And they basically came to what the highest amount of which is normally charged, which the industry norm at that stage I think was 6.5%. If we go today's standard, it's 7.5%. So what happened was, in the absence of the mandate, whereas possibly had there been one, Mrs. Swart might have agreed to a lower commission, she actually ended up agreeing to the court came down in her favour and said that her actions were sufficient to show that she was the effective cause of the sale, and it said that the industry norm is as high as possible amount, which is 6.5%, and they found in her favour, and that was the amount of commission that they ordered her to pay out. So yeah, so it was a very good result for obviously for the company and for estate agents as a whole, to know that if you are pushed, that at the end of the day, and you've done your job and you can be shown that you worked hard and that you are the effective cause, that the court will come down in your favour. Right? The court will come down, and in fact, it was like I said, it was originally taken on appeal. It was originally a magistrate's court judgment. The magistrate, the court found, didn't properly go through the facts, and they found that even the evidence, his reasoning was lacking. The point is, so the court will, you do your job, show that you're the effective cause, have this extra evidence that you can document that indeed you were the one who did all the work. The court will come in your favour and will help. However, the problem with that story is that to get to that point, it's a struggle and a fight, and like we've seen from the prelude, that there are obstacles that could be thrown in your way. I mean, it could have been a very, very different situation if we look at the story. If the purchaser and the seller had colluded and turned around and said, yeah, well, Mrs. Swart took me to the property once, but beyond that she didn't really do much. And me and the seller, we were negotiating every day, and we spoke every night, and we went backwards and forwards and whatnot. So it could have gone very differently. And thus, I return to my original starting point is, if you can, don't put yourself in this situation, and make sure that the paperwork and the agreements and those kind of things are in place. If you do get to the point where unfortunately all that kind of stuff isn't there, then yeah, you can go to the court, but bear in mind that it's going to be difficult, and bear in mind that the less paperwork there is, the greater the likelihood it is that we're going to have to go by way of trial, which means that there's going to have to be verbal evidence, and people are going to have to get into the stand, and there's going to be you getting into the stand, there's going to be the seller getting into the stand, potentially the purchaser getting into the stand. And I think someone said someone said a very four-letter word in the legal language, which is cost. Because these things do cost. And the truth is that to go through a trial, we're talking about probably at best 2 to 3 years down the road, which is for a com, it's a very long time to wait, considering that you've already done the work and you've already had to wait for the registration of the property. So, there are tricks that can be pulled. The trick is to try. The ideal is to not be in that situation where we turn around and say, "Oh dear, there's nothing binding me to the seller," and because again, like I said, if there's a situation where the purchaser and the seller start colluding, then it's definitely going to have to go by way of trial, and then you're going to have a very, very sharp advocate or attorney who's going to be doing the cross-examination, who can whittle out this whole story, and it becomes very, very difficult.
Don't worry, we are your sharp advocates and attorneys.
Go Burton. Trust you.
So that's basically the story. The story is there are means available. The most important thing that the court does look at, and the guiding principle that it defines itself on, is effective cause. Even in instances where there is no paperwork behind you, that it's not necessarily a dead-in-the-water situation, there is relief available. But like I keep saying, let's not be Mrs. Swart, if we can. Because, whilst, like I said, whilst Mr. Swart in 2000 was happy, I can promise you that up until that point in time, it was very stressful and it was very difficult. And there is a situation where sometimes you have to turn around and say, is it worth my while to now fight, to now go through a protracted legal battle to fight for that commission? And then it's a very difficult situation where you turn around and say, is it worth my while to fight for the fruits of my hard work, or must I now turn around and just say, you know what, I'm just going to have to leave it, which is a very unpleasant situation to be in, and I hope none of us find ourselves in that position. Thank you. Hope that helps.
Is the effective cost. If you take somebody to a property and that person doesn't sign an agreement then, and maybe 6 months down the line, that person that you've introduced to that property buys it, and and maybe you're not involved in that 6 months down the line, but it's the same property, the same person.
So your truth is that officially there's no, from what I've seen, there's no regimented official cut-off date that the property has to be sold within 6 months from the time that you've introduced the purchaser. Obviously we're talking a situation where there's no mandate, right? Officially there's no official cut-off date. Your problem is the greater the lag between your introduction of the purchaser to the property and the conclusion of the sale, the harder it's going to be to prove that you were the effective cause, especially if your involvement in the deal lessens, if that makes sense. So in other words, if, let's say that you initially introduced the purchaser to the property in January, and then there was a little bit of backwards and forwards between Feb and March, things got quiet, property doesn't get sold, August, September, the purchaser picks up the phone and says, listen, do me a favor. Okay, so I'm willing to offer another 200k more, do me a favor, make contact with the seller. That kind of an instance, even though there's been a bit of a lag, because you've been involved in, you can still show that you've been the effective cause. The problem would come if the reverse happens. Let's say you introduce the purchaser in January and you're involved in the negotiations in Feb, March, and then it goes cold, right? And purchaser loses interest, he stops returning your calls, the seller's no longer interested in you, he's moved on to 2 or 3 other brokers, and then down the line in August, September, the purchaser picks up the phone to the seller and says, listen, do me a favor, you know what, I've changed my mind, I want to take the place, I'll meet your price. And you hear about it because your mate happens to be selling the building next door and says, I saw apparently the thing's going through. Now in that second instance, I'm not saying it'll be completely dead in the water, but it's going to be tough, because what's going to happen is that, without being too crystal ball on the subject, that the purchaser and the seller are going to turn around and say, yeah, well, the initial introduction was made, but the actual cause of the sale wasn't necessarily the agent. That's why the court doesn't just purely look at the introduction; it looks at the effective cause. So there is a little bit more to it that goes on. See, this is again where the strength of the mandate comes in, where your mandate could turn around and say that if the property is sold during any time, or if you can even protect yourself, say, okay, maybe it's in a situation whereby the seller's not willing to sign a sole mandate, but you can say that should any person who I introduce to the property end up buying the property, that I'm entitled to the sale. I'm entitled to my commission. So in other words, even if that caters for a situation where there are multiple agents, and even if it does go quiet during that point in time, that even if the sale later occurs, that you can still get your car. Also, it protects you in a way that even if you completely aren't the effective cause, that essentially you contract out of that effective cause test. And the court then purely does the test of, did you make the introduction? And obviously your records will show that, because you'll have your sign-ups, be it a show day, or you'll have documentary proof to show that you took them to the property. So that would improve your prospects.
Will the court consider emails as well, because emails is not an official document?
So yeah, it will. Emails, even WhatsApps and SMSs and whatnot, it can be adduced as evidence, and it will come to your aid. obviously the more of those kind of, that kind of correspondence that exists, the more extraneous evidence that you can put before the court to say, hey, look, you know, I didn't just bring this guy around. I worked my bottom off to get to this point. You know, I took him and I showed him and I took him again and I took him again and I've got him the plans and I took him to the town council and we got the rates clearance and he told him everything else that was going on in the street. I did my work. So all that extra documentation would help. However, it's still going to make it a little bit more complicated. But to take it a step further, let's say you get an email from the seller who turns around and says, great work, I look forward to paying your commission or something like that. Those kind of, or great work, thanks for helping us conclude this deal. Those kind of remarks, be it in an email, be it in WhatsApp, be it in SMS, they can be beyond gold into your case. But also remember that the problem is that a lot of that kind of stuff is going to be at the tail end of a trial.
Sorry, what if it's not the buyer and the seller colluding? What if it's just another agent that steps in?
So that, believe it or not, is not a rare situation.
I'm sure.
Believe it, the guys in your industry who aren't completely ethical. So you're right, it is a problem, and it is not one that is not encountered upon. The truth is that it will depend on what other extraneous evidence you can put before the court to show that you were the effective cause. The big problem is going to come in is if we have to turn around and say, I'm the guy who caused this agreement, and the guys who sit on the other end are the purchaser, the seller, and the other agent, and they say, no, that guy was the effective cause. Because then it becomes very difficult, because then you basically are getting the purchaser and the seller to agree that the reason that they ended up entering into the agreement wasn't because of the guy who they say it is, but because of you. So evidentially, it will be very tough. It's not unassailable, but you basically have to show that all three are liars, which can happen. I've been in situations where we've managed to do that, but the truth is, it is putting a great degree of difficulty. Whereas truthfully, if there was that contractual protection beforehand, and sorry if I keep harping on about it, but the truth is that their paper trail and the paper stuff, it works. But again, like we were saying, this is where even if you don't have that agreement, the emails, the WhatsApps and things like that would help your case. But again, you're also going to have to determine is it justifiable in terms of the costs. Yes, sir.
So what you're saying is there's no clear cut in terms of who's the effective cause of the sale. It depends on circumstances to the greatest.
It will be
sense of that,
circumstances. It will be circumstances. Like I said, that there are these two tests that have been introduced by the court. And again, we're talking about instances whereby we're completely free of any kind of agreement.
But in the instance where, say, I take a client, a buyer to your property, and the price is 2 million, they're not prepared to pay that price at that stage. 2-3 months is reduced to 1.8, and another agent takes the buyer pass, then they actually sign the contract. Is there a clear-cut case then, or is it still disputable?
So theoretically, it could still be disputable, right? Ideally, that if there was someone from the estate agent's board sitting next to me, they turn around and say, no, but the second agent shouldn't take them. If you've already taken them, it's your client. And it's completely unjust, it's completely unethical and not in line with the estate agent's ethics for the second agent to do so. The truth of the matter is that, as you know, I don't need to tell you, that does happen. Now, if what will happen is, let's say you make that initial introduction, and you put and the seller's happy, and the purchaser's happy, he puts in his offer, and the seller rejects, and then a few months later the other agent takes him through.
No, there's no offer at the beginning.
There's no offer. You just take him through, right? Yeah. And then later the other agent takes him through and concludes the deal. Now the problem is theoretically you can turn around and say, yeah, but I was the effective cause of it. The problem that you're going to meet is when you turn around in court that you can't account for that period of time between the second estate agents taking them to the property and the conclusion of the deal. You don't, because what could happen is that now they're the ones who turn around and say that they've got the offer to purchase, where it says that they introduced, and that they've got the sale agreement, or even not the offer to purchase, that they've got the sale agreement, and the sale agreement agrees that Joe Blogg's estate agents was the effective cause of the sale. Specifically, Mr. Piet van Niekerk was the guy who actually did it. In which case, you now find yourself in you'll find yourself in a difficult situation where you've now got to explain that even though there's all this contractual stuff on their side, that truthfully you were the effective cause, and truthfully it would be difficult. It's not to say it's impossible. Obviously, if you did all the groundwork and this other guy just rocks up, and what I think is far more common is that the estate agent does all the work, does all the show days, takes them left, right, and centre. Parties decide that they want to buy the that they want to do an agreement, and they kind of wait for the mandate to expire, or they just speak to one another without the agents. They manage to find a way of exchanging numbers, and they just conclude the sale agreement between the two of them. I think that's slightly more common and slightly more and a difficult situation. But however, even there it can be overcome, but it's difficult because again you're going to have to argue in the face of agreements, which sometimes the courts do prefer. Okay. Yes, sir.
Mark, you mentioned something about the insertion of a clause relating to a claim of commission. Does that insertion of a clause, if you word it as such that you're entitled to the commission if you the first introductory party to the purchaser, does that override then the clause which refers to the effective cause of sale?
Potentially it could.
So
the truth is though that's what I'm saying. The best situation you can find yourself in is to deal with these issues at the conclusion when you're concluding a contract, and to have a contractual case to rely upon takes your case from here to here. So in other words, let's give you the situation.
So it rises above.
The truth is that actually the person who would really stand to lose in that situation is a seller. Because let me explain to you why. You put a clause in your mandate saying, irrespective, I introduce you to somebody,
You pay me.
I make the introduction, you pay.
Yeah.
Right? And let's say the seller signs that agreement.
Yeah.
Whatever happens down the line, you don't end up doing it, somebody else signs gets the sale, they do the legwork, they conclude the agreement. Right?
Yeah. They're the effective cause of sale. So
They're the effective cause of sale. Officially, you'll find yourself in a position where you can turn around and tell, where agent B is going to turn around to the seller and say, listen, you and I have a contractual agreement. In terms of this contract, when I conclude this sale, I'm entitled to my commission. You'll turn around and say, irrespective of whether or not I am or am not the effective cause of the sale, by virtue of the fact that I make the introduction, I'm entitled to the sale. I'm entitled to the commission. Which essentially means that the seller can find himself in a position where he's got to pay 2 commissions. Because now, because there's a very, in law school, ask anyone who's ever been to law school, even a guy who dropped out within the first year, he'll tell you 2 words from Latin. And a lot of guys who've been around business will tell you these 2 words also. It's called caveat subscripta, which means, let the signer beware. If you know only 2 words of Latin, know those 2.
thank you, I'll use those 2.
So as you leave from your thing, say caveat
Caveat subscripta. So, yeah. Once you've signed, it becomes very, very difficult to get around that signature.
Thank you for that.
It makes life complicated. Thank you very much, everyone, for coming. Hope it was beneficial and enjoyable. Myself and my colleagues will still be around to answer any questions that you might have. And thank you very much. Please stay.
Agents who told me this might even be here, so just raise your hands if you were them. They said that after a show day, it might have been you, John, they email the seller to say that the following people came through the doors of the show day. And if they are to purchase the property at some stage, then please keep me covered for the commission. So as Mark said, a lot of it's about keeping a trail of emails, WhatsApps, that if there is a dispute at a later stage, you've got something to show that this is your person that you brought to the party. You're all welcome, if you like. Email us your mandates tomorrow. We can have a look at them. And because we deal with this so often, it will be quite easy for us to tell you quite quickly what should come out and what should come in. And as Mark said, that can make a world of difference when that time comes that you have to litigate. And I get calls 3, 4, 5 a month with agents who have a situation with commission. And normally I put them straight on to Mark. And Mark gives a very honest, experienced advice to them. And I'm very happy to hear that some of them tell me that Mark told me to forget about it, that it's not worth going after. So please chat to Mark, please take his card and expect to get honest advice. Not advice that suits us to chase a case that may be lost, but advice that suits you and will tell you whether it's really worth your interest or not to fight it. I just wanted to thank Mike Hitchcock for also coming at the back. We appreciate it. And I wanted to let you know that in the audience we have 4 secret agents. I never had black tape to seal their lips when they walked in, but there's 4 other attorneys sitting here from other firms. But I've confiscated their cards, so no talking to them. But we're also very fond of all 4 of them, and thank you for coming and supporting our firm. Please all stay for a drink, some networking and socializing. There is a prize for the client who stays the latest.
I've won. Thank you. I've won already.